Can a DWI be reduced to a lesser charge? Should you even consider it if it's offered? Hi, I'm Jeff Hampton with the Hampton Law Firm. Welcome to our YouTube channel. Today, I want to talk about negotiations. I want to pull back the curtain and share some information with you. Most attorneys don't tell you. Does it make sense to take a reduction? What DWI cases should you expect you might receive a reduction offer on? And should you even consider it based upon your options? By the way, if you wait around to the end of this video, I'll also give you a free ebook, The Ultimate Guide to DWI Defense in Texas. Okay, now in the North Texas area, the standard kind of traditional way that the district attorney's office lowers a DWI charge to a lesser charge is they may offer what's called an obstruction of a highway or obstruction of a roadway charge in place of a DWI. Now, before we get into that, before we get into whether or not it's worth considering or not, first of all, let's just define what the charge of obstruction of a highway is. So when you look at obstruction of a highway or passageway, please understand being convicted of this charge has long-term consequences as well. In fact, it is a Class B misdemeanor punishable by up to 180 days in jail and up to a $2,000 fine. And anytime you're convicted of a crime, particularly one for which there's an arrest record, it can affect your employment, long-term opportunities, different things like that. So it's important to differentiate and distinguish here. We're not talking about most prosecutors offer like a ticket or something. They're usually going to just change the charge from a DWI to a non-alcohol related offense like an obstruction of a roadway or highway. All right. Now, what is the offense of obstruction of a highway? The most common situation is when a person stops their vehicle in traffic and ends up holding up traffic or refuses to move their vehicle. According to Texas Penal Code, Section 42.03, a person commits the crime of obstructing highway or passageway if, without legal privilege or authority, he intentionally, knowingly, or recklessly, 1, obstructs a highway, street, sidewalk, and then we have a list of other things, more specifically, to which the public or a substantial group of the public has access, or any other place used for the passage of persons, vehicles, or conveyances, regardless of the means of creating the obstruction, and whether the obstruction arises from his acts alone or from his acts and the acts of others. So it sounds like what it is. If you're obstructing an area from which the public has access getting back into, that's an issue. Or number 2, disobeys a reasonable request or order to move issued by a person the actor knows to be or is informed as a peace officer, a fireman, or a person with the authority to control the use of the premises to prevent obstruction of a highway or any of those areas mentioned in the previous subdivision, to maintain public safety by dispersing those gathered in the dangerous proximity to a fire, riot, or other hazard. Now that's a bunch of mess, but basically what does that mean? That means that if you are obstructing an area from which the public has passage to get back and forth, that could be the crime. Or if you're told to move by a police officer or someone with authority and you choose not to, that can also be obstruction of a highway or passageway. Now the weird thing about that is it has nothing to do with DWI. I mean, it has zero to do with DWI. But this is the crime that's often used. Now, let me just explain. The word obstruct, what does that mean? Obstruct means to render impassable or to render passage unreasonably inconvenient or hazardous. So, look, you don't want to be convicted of this charge as well. It's not anywhere near as bad sounding as a DWI conviction, but receiving a conviction for an obstruction of a highway still clutters up your criminal record. It's something you would have to explain. So if you're in a position where you're starting to think about an obstruction of a roadway, or this is something you've heard about, beware taking a conviction to that offense, okay? Now, let's talk for a few minutes about what happens behind the scenes in plea negotiations related to a DWI and an obstruction of a highway or other lesser charge. Because what does this crime have to do with DWI? And as I've already articulated, it has almost nothing to do with the DWI. Now, let me just say this. Any good DWI attorney is out there trying to do the best that they can to provide options for their client. It's very important. Most people have the same goal when they come in for a DWI. They do not want to go to jail. They do not want to be convicted if at all possible, and they want to be able to get it off their record. Okay? So understand, if you receive an offer for a obstruction of a highway as opposed to a DWI, it does help you avoid some collateral consequences that only come with DWI cases, and we'll get into those in just a minute. But let's talk. Some of the reasons why people say is, well, how do I know? Like, if it's available, why can't my case get an obstruction of a roadway? Let's talk about cases that tend to be more eligible to receive a reduction. And whether it's obstruction of a highway or not, you want to receive a reduction to your DWI. How does that happen? Well, there are a few things that a good attorney looks to analyze. So your DWI attorney should tear apart your evidence, get access to the police reports, the videos, and as part of doing that, I'm going to outline a few areas where we have been able to receive offers of obstruction of a roadway based upon problems with the case for the state of Texas. Because remember this, the state of Texas must prove every element of the crime of DWI beyond a reasonable doubt. Failure to do so, or any other problems that may arise, could provide leverage to your DWI attorney to help negotiate you that favorable result. Okay, so one area that we find that exists is lack of reasonable suspicion or an illegal traffic stop. Now, what if the DWI officer fails to articulate a legal basis for pulling you over? What if your DWI attorney evaluates the evidence and sees that there was no traffic violation that was committed? Maybe the officer just pulled you over based on a hunch, and there's nothing really there to substantiate why he did what he did. Your attorney's ability to be able to show that can actually provide some flexibility with being able to negotiate a more favorable result for you, okay? Now I'm just gonna hit these one in a row, just kind of one after another. The next one is lack of probable cause to arrest. What if you were given field sobriety tests, but they were administered improperly? What if the police officer did not follow the guidelines promulgated by the National Highway Traffic and Safety Administration for those field sobriety tests? Please understand, tests are only as reliable as the officer administering those tests doing them properly, okay? If they're not administered properly, if they're not displayed properly, then they may not be reliable, okay? Then what about failure to follow protocol in breath or blood testing? What if the intoxilizer operator on the breath test administered that breath test improperly? What if the person that drew your blood was not a qualified technician? Each of these issues can play a critical role in whether or not that breath or blood test is even admissible in court, okay? Now, what about lab failures on the part of the blood sample? What if that blood sample was taken and the vials were not sealed properly? That can cause spoilage. That can also cause alcohol to show abnormal high levels of alcohol, okay? What if the person testing the blood did not follow the chain of custody and that there is a break in that chain of custody? What if the technician failed to follow established protocol for blood testing? These are all areas that your DWI attorney needs to go over thoroughly with you. And understand, any type of problem with this along the way creates leverage for a possible lesser charge, if that's something you decide to consider. Now, what factors should be considered for taking an obstruction of a highway instead of a DWI? This is where we need to get into this. First of all, let's talk about the pros and cons of a DWI plea deal compared to an obstruction or a lesser charge plea deal. I'm not assuming you should take anything, but I'm just saying, if this presents itself, how do you think about this? How do you decide the pros and the cons? Well, number one, DWI convictions are very expensive. Receiving a DWI conviction, whether you're receiving jail or probation, can result in a suspension of your license. You can have costs associated with an occupational license, what used to be called surcharges and fees from the Texas Department of Public Safety that you have to pay over a period of time. And as an example of that, a first-time offender DWI, if you're a first-time offender and you receive a DWI conviction, you can result in having to pay what I call a DWI tax of at least $1,000 a year for 3 years. You'll see a dramatic increase in your car insurance premiums, as well as a possible jail sentence of a minimum of 3 days. And now look, I'm not saying those things are going to happen, but if you go to a trial and you lose, those are all considerations when you consider the pros and the cons. Now, obstruction of a highway, on the other hand, hand, let's consider that for a moment. Obstruction of a highway charges are what some people would call less embarrassing, which means everyone knows what a DWI charge is. But very few people really understand what obstruction of a highway or a roadway is. And in fact, most people don't associate a negative stigma with that. They just think it means your car broke down in the middle of the road and you didn't move it. So there is an element to consider of how that charge appears on your criminal record, okay? Now, if you take an obstruction of a highway charge instead of a DWI, here's the other question I get all the time. If I take the lesser charge, can I still clear it from my record? Well, the answer to that is it depends. It's critical that you're working with a DWI attorney that absolutely knows the rules for getting things off your record. Whether it be an expunction or a non-disclosure, it is critical. For example, some jurisdictions in North Texas only offer straight probations. And let me just lay this out for you. Let's say you've got a DWI case. Let's say there's problems with it and your attorney goes in, negotiates a lesser offense or a different offense down to a charge of an obstruction of a roadway. But let's say now that prosecutor is offering you a straight probation instead of a deferred adjudication probation. This is critical for you to understand. If you take a straight probation to pretty much any offense, you have now been convicted of that offense and you are barred from being able to get it off your record at all. Okay, so what I mean by that is we've had many people call our office and say, hey, Mr. Hampton, I got my DWI case 3 or 4 years ago lowered to a lesser charge to an obstruction, and I took a straight probation. I'm ready to get this thing sealed for my record. And I have to break the bad news to them that their attorney did not adequately explain to them the reality that when this sort of thing happens, if they did not take a deferred adjudication probation, they can't get it off their record ever. Okay, so if you do decide to move in that direction, it is critical that you are working with a DWI attorney that knows the rules of how to get things off your record. Because for most people, particularly first-time offenders, it's critical that they're able to get that DWI arrest off the record in some way, okay? Now, here's the question that comes up a lot to me. Is there ever a time that someone should reject an obstruction of a highway plea deal when facing a DWI? Well, for some people, think about this for a second. For some people, facing a plea deal to an obstruction of a highway is not an option. Texas laws have changed in the past few years regarding the availability of potentially sealing your record for a first-time DWI charge. Under current Texas DWI law, you can take a first-time DWI case, which has a blood or breath alcohol level under 0.15. You can still take it to a potential jury trial and lose and still qualify for a non-disclosure. And I know that sounds crazy, but you actually can. As long as you're under 0.15, your blood alcohol level is under 0.15. So for some clients that have a lot to lose here, they would almost rather push the case further in that direction and potentially even to a trial if they know they could still potentially get that off their record under current Texas DWI law, okay? Now, what's the benefit here? If you win at trial, if you decide to go to trial, winning at a jury trial, your case could then be eligible for an immediate expunction of both your arrest and your DWI case records. An expunction, just to be clear, is a complete and total destruction of all records pertaining to the arrest and the case. What if you lose? Well, if you're a first-time offender and you're under 0.15, if you lose, you could still complete the terms and conditions of your DWI probation, and upon completion of the waiting period, you could still be eligible for a non-disclosure, depending upon your circumstances. And I'll tell you this right now, make sure that you're consulting with a DWI attorney, and we're happy to do that with you to make sure that that would be the case, okay? Now, as you can see, there's many factors to consider. Some people just assume if I can get a lesser charge, I should take it. Well, there's a lot there. The last thing you want to do is think you're getting a great result only to find out later you made the wrong decision in what you should do. So at the Hampton Law Firm, one of the things you have the opportunity to do is to collaborate with a team of former prosecutors. We have over 85 years of criminal experience, over 500 jury trials. Many of those are DWIs. And we want to offer you a free case analysis. If you are interested in that free case analysis and free consultation, I encourage you to call the number that you've seen up here above me on the screen. Contact that number schedule yourself a free consultation if you have a case in the North Texas area. We'll be happy to answer those questions and see what options exist for you. But by all means, at least now you know what happens behind the scenes in negotiations on a plea deal for a DWI. Thank you again for joining us here today. Oh, I almost forgot. If you click the link down below, I'll be happy to send you a free ebook, The Ultimate Guide to Your DWI Defense in Texas. Thanks for joining us. We'll see you next time.